Hey, welcome to the webinar. So today I'm recording this webinar for my clients and anyone who's interested. The intention is really to give you some very good, empowering information. And this is titled Estate Planning is for Everyone. And we're going to be demystifying one of the most important things you will ever do. So there's kind of a common misconception that estate planning is only for the uber wealthy, but that is not the case. And we're going to dive into everything on this presentation. So thanks for being here. And I hope you get a lot of value out of it. I'm going to introduce myself first. My name is Julia Baginski Brandt. I am partners with my husband, Arthur Brandt, at Baginski Brandt and Brandt PA. So our law firm has a litigation side that is headed by my husband, Arthur Brandt. He handles family law, criminal defense, personal injury, and then the other side of the practice is the estate planning side, which I focus on wills, trusts, and estate planning. So that is solely my focus in law is just these matters. So I graduated law school from Stetson University College of Law in 2004. And I moved to this Treasure Coast area in 2007. So I've been here ever since, even though my grandparents did retire to Port St. Lucie in the mid 80s. So I'm very familiar. I've been in the area for a long time. So currently I'm super active in ongoing estate planning education, continuing education. This is definitely an area of law that is constantly in flux and changing. So you really need to be on top of all of that as an attorney practicing in this area. I do currently serve on the board of the Martin County Estate Planning Council. I'm a member of Wealth Council. I'm also a member of the Real Property, Probate, and Trust Law section of the Florida Bar. And in addition to that, a little bit of like on the personal side, um, I also have a daughter who just turned 12. I have two stepkids who are grown, 23 and 28 years old. And another fun fact is I also serve as a church minister in the town I live in, Jensen Beach. So enough about me. I'm going to jump right into the presentation and let you guys know what we're going to cover today. So really having an estate plan, I think for a lot of my clients and a lot of people, getting an estate plan prepared can just sound like such a big challenge, like a monumental challenge full of emotion and legal terms and complicated numbers and computations. So I'm really here today just to answer some of what I've found to be the most common estate planning questions and explain kind of the different reasons why you should have an estate plan prepared. And then we'll take a look at the end of the presentation at what documents make up an estate plan. So first, we're going to cover just some of the common questions about estate planning. If you're not sure what estate planning is or why it's important, don't worry. Many people are in your shoes, and I am also here just to answer your questions and explain these concepts so we can create a plan that'll work to protect you and your loved ones. And you'll see a way to contact me at the end of the presentation so that we can talk about your individual needs one-on-one. So here we go. What is an estate plan? When most people think of an estate plan, they think of a document that says what happens to their stuff when they die. Although this is part of what an estate plan does, it's not the only thing an estate plan can address. So a comprehensive estate plan can also answer important questions about what will happen when you're incapacitated. You can't make or communicate decisions regarding your finances or your medical matters. One of the first questions an estate plan can answer is who you want making medical decisions on your behalf. However, whoever you do decide to choose must be someone you completely trust. Also, estate planning allows you to specifically state what your end of life wishes are. Do you want to be resuscitated, kept on life support, receive artificial hydration and nutrition if you are in a persistent vegetative state, or a terminal medical condition? Do you want to donate your organs? So, an estate plan also allows you to state how your accounts and property are to be managed if you can't do so for yourself, including how the money and property should be used to take care of you and any loved ones that you may be supporting. So, your estate plan is an effective way to convey also your hopes, fears, dreams, and values to your loved ones through the estate plan itself, or even by leaving a letter to be read after your death, a recording of or a video for your family, or just having money and property distributed to your heirs in a specific way. All right. So, what if I don't have an estate plan? Well, this is kind of like an ironic question because everyone actually has an estate plan. And although some of you have done no official estate planning, that doesn't mean you don't have an estate plan. If you have no plan, state of Florida actually does have a plan for you. So the state law is the default plan for all situations, incapacity or death. These are what are called intestacy laws, and those are essentially the state's kind of best guess as to, who you would want property and money going to and who you would want making decisions for you or taking care of your important matters. So there are default outcomes which may or may not align with your specific wishes. So the court, in referencing these laws, would determine who would make financial and medical decisions for you if you couldn't, who would get your money and property at your death, and even who would raise your minor child if you are the sole parent. So, a great place to start is understanding just what is probate. We've all heard of probate. Although probate gets mentioned a lot in discussions about estate planning, people often forget to explain exactly what probate is. So, simply put, probate is the court process of determining if you died with a valid will, who will be named to wind up your affairs, and who will receive your accounts and property. While this might sound very straightforward, probate can be very expensive and time consuming, and it is open to the public. Once people learn what probate is, usually they prefer to prevent their loved ones from having to deal with it. So, when would you need probate? So, as we just mentioned, probate is that court process of determining who gets your accounts, your property, um, particularly those things that are in your name alone. If there is a joint owner with right of survivorship or a beneficiary designation instructing who would get the account or property at your death, those items would not need probate. But note that if you die with no estate plan, your accounts and property will go through probate, even if you don't have a will. Also, if you die with a will, your accounts and property will go through probate if they are only in your name when you die. So here's probably the next question that you're wondering about. Can I avoid probate simply by adding someone as a joint owner? All right. So it is technically possible to keep an account or piece of property from going through probate if you add someone to the account or property as a joint tenant with right of survivorship. At your death, your co-owner would automatically receive 100% ownership of the account or property without probate court involvement. Though this could accomplish your goal of avoiding probate, you're now exposing yourself to much more risk while you're still living. Because you've added someone as a current joint owner, that account or property will be considered partly theirs. Therefore, any of your new joint owners' creditors may be able to take your account or that piece of property. Also, especially with bank accounts, by adding another owner to that account, you're granting that person complete access to all the money in that account. Your new joint owner can now at any time go to the bank and drain the entire account, which would be an unfortunate and undesired outcome. So we sometimes see clients add an adult child to a bank account to help with bill paying. However, we counsel clients that when they die, this child will automatically become the new sole owner of the account and all the money. The child has no obligation to share the money with the siblings, regardless of any verbal directions or what your estate planning documents say. So, depending on the value of your account or property that you change to joint ownership, there could also be gift tax consequences. So this year in 2024, you can give an individual up to 18,000 per year without having to file anything with the IRS. However, if you made previous gifts in the calendar year and the total is more than that 18,000, you would have to file a gift tax return with the IRS, and the amount that would count against your lifetime exemption. So just something to be aware of. Now, can I simply fill out a transfer on death or pay on death designation? Another thing my clients often wonder about. Now, for some accounts and types of property, there may be an option to name a transfer on death or pay on death beneficiary. Based on this designation, that account or property would automatically be given to the named person at your death, either through liquidation or transfer into their name. Although this designation can accomplish the goal of avoiding probate for this account or property, it also introduces several dangers. So, with the transfer on death or pay on death, the account or property is transferred or paid directly to the named person. This means the account or property now becomes vulnerable to any of their creditors' judgments or divorce proceedings. So, what are some estate planning solutions? Now that we've poked some holes in those commonly held beliefs and myths that probate can be avoided through simple do it yourself methods, you may be wondering, what are the ways to avoid probate and prevent the court from dictating who receives your hard earned property and accounts. There are several solutions available through thoughtful estate planning. So, as we discussed earlier, the key to avoiding probate and the state determining who receives your stuff is to die with no accounts or property in your name. However, you still need to protect your accounts and property during your life and after your death on behalf of your chosen recipient. This is where a revocable living trust can come in handy. It's kind of where you get to have your cake and eat it too. All right, so let's talk about creating a revocable living trust. First, you create a trust. You can think of it like a bucket. So that little blue dot in the middle of the screen is that bucket. For this trust, you will name a trustee, which is an individual or entity in charge of managing, investing, and handing out money and property to the appropriate people. Remember, in the beginning, during your lifetime, the trustee is usually you, and possibly your spouse if you're married, and could be co-trustees. So you will also name a successor trustee who would take over if you die or if you become incapacitated or unable to carry out those duties. Okay. And next, when you're creating your trust, you'll determine who should have access to the money and property that would be put into that trust. While you're alive, you'll be the current beneficiary. And if you are married, your spouse for his or her lifetime. But then you will need to name who you want to receive your money and property at your death. Those are your beneficiaries. And if you're married, your spouse's money and property. And in addition, you can specify when these individuals or organizations will receive the money and property and how the money and property will be used for their benefit. This all takes place during the design process, which is very unique to each client. So most importantly, you're going to change the ownership of your accounts and property from you as an individual to you as the trustee of your trust. This change puts your money and property into that trust bucket. Anything that's in your bucket does not have to go through probate when you pass away, and it can be managed by your trustee during your incapacity. If you skip that step of placing, titling assets into trust, the trust may not work as intended. So this is really important. The trust documents provide a set of instructions for accounts and property owned by the trust, things in the bucket. If there are no accounts or property in the bucket, the instructions are worthless. So changing the ownership designation can include signing a new deed for your home or other real estate and signing documents to change ownership of your bank or other investment accounts. In some cases, you may decide to use a beneficiary designation for some of your accounts, naming the trust as your beneficiary at death and keeping yourself as the owner of the account. However, you should not make the trust the owner of your retirement account. Given the unique tax considerations surrounding a retirement account, you should look at your individual situation and figure out the best planning strategy to meet your needs and goals. And so this is how the trust accomplishes your goal by privately passing your assets to your heirs and beneficiaries while avoiding probate court. All right. So now that we've addressed some of the common estate planning questions and walked through how a revocable living trust generally is set up and can help your loved ones avoid the time-consuming, expensive, and long public probate process, you may still be wondering if estate planning is something you should even be worried about. Many people mistakenly believe that only the uber wealthy need an estate plan. Next, we're going to take a look at some everyday situations in which estate planning is necessary to properly care for and provide for your loved ones. So first, of course, is appointing a guardian for your minor child. I think the most sad circumstances are when there is no planning and there is a minor child where both parents pass away while the child is a minor. And they didn't plan. Maybe they didn't think they had, enough of an estate or enough money to even consider doing estate planning. However, the fact is that even if you die with debt, that surviving minor child is going to receive Social Security and benefits. And what would end up happening in the worst circumstances, of course, it's like the wrong people crawl out of the woodwork to try to gain guardianship and custody of the child so that they can collect that check. So planning is so important if you do have a minor child. Now it's just crucial just to consider naming someone to look after your child in the event you and the other legal parent cannot. So there are temporary guardianships. This is a different type of document that can be created as part of your estate plan. This can take effect to give that person that you name power to act for a short period of time while you're still alive. So this doesn't happen with your will because the will only takes effect after you die. So this is a separate document for temporary situations. So if you would need a temporary guardian, it is a separate document that allows that caregiver to be able to handle any situations that may arise. So this could be if you travel for extended periods of time, if you yourself become incapacitated or something of that nature. A full guardian is someone who has the legal authority to make decisions for your child and has legal custody of your child in the event of your death. Because the triggering event for full guardianship, like I said, is your death, you would name the person that you want as guardian in your last will and testament. So we would include that even if you're creating a trust, that would be where we would need the will. Um, so the next consideration is protecting your minor child's inheritance. Because remember, I mentioned they would be getting potentially government benefits, things like that, even if you don't think that you have set up an inheritance for them. It's always a good idea to, protect your children with a life insurance policy and things like that, that you can get taken care of very easily with a financial advisor. But here's how we're protecting our child's inheritance. Now, you might have somebody in your family who you would want to be the guardian of your child. Like, this is who my child should go live with because their house is really this fun environment and they're very nurturing. And I would love for my child to live with them if something happened to us. But maybe that person isn't the best with money. With estate planning, you can have two separate people involved in your child's care. So while you have one person that is their physical guardian, another person is financially responsible for their health, education, maintenance, support, and providing enough money to their physical guardian to take care of their needs and making sure that they don't overstep or do anything unnecessary with those funds. So you can actually have two people involved in this part of the planning. So it's important to protect properly any money or property that your child could receive when you die. So according to the law, minors cannot own accounts or property in their own name. So anything your child would inherit from you, absent proper estate planning, right? So if there was no estate planning, would have to be overseen by a court appointed conservator and the probate court. Also, once your child reaches the age of majority, which is 18, only 18 years old in the state of Florida, your child will receive his or her full inheritance. This means your child is free to spend the money in any way. And it could also be now seized by creditors or less than reputable people who prey on those with newfound wealth. Okay. So one solution is to proactively create that trust for your minor child. As we discussed with that revocable living trust, that trust allows you to name someone to oversee those accounts and property as part of the trust. And this is someone that you choose, not the probate court or judge. And it doesn't have to be the guardian of the person. You get to determine when and how the money and property are to be used. And you also can state if and when your child has the ability to manage the money and when your child can have full access to that money and property, if ever. Okay. All right. So besides our children, our minor children, maybe we have adult children or just others that may need help protecting their inheritance. Um, Usually minors are the first people we think of when we're looking to protect an inheritance, but there are other groups of people that could benefit from proactive estate planning. Specifically with the creation of a trust on their behalf. So the most obvious is someone who's bad at managing money. This is someone who maybe routinely forgets to balance the checkbook, someone who spends every available dollar. A potential beneficiary who's bad at managing money will most likely spend every cent inherited from you in a short period of time. So if this is not the outcome you want, a trust can put restrictions in place to avoid that. Another beneficiary who needs extra protection is someone who has current outstanding debts. That person may have started out in that first category, but instead of just spending every cent, that person spent more and now owes money. So if this beneficiary receives money or an inheritance directly, creditors can go after it and take it. If your intent is for your chosen recipient to get some benefit from your legacy, such as attending school or having funds for medical care or an emergency, a trust can help. And then on the other end of that spectrum is the potential beneficiary, who, by all definitions, is one of the most responsible, right? That beneficiary could be a doctor or a business owner, right? And this person would not be in that position if they were not trustworthy or responsible. However, the nature of their occupation or career can attract lawsuits. So, if you want to make sure that this beneficiary actually inherits from you and can benefit from your legacy, consider using a trust instead of having money and property given directly to them. And finally, divorce. So, statistics show that a majority of marriages end in divorce. Therefore, if you intend to leave money or property to a married beneficiary, consider the possibility and the potential outcome if your beneficiary were to get divorced. While a trust cannot hide accounts or property, it can offer better protection than the beneficiary would have if he or she received all of it outright and possibly commingled it with the spouse's property. And on the other side of that coin, just as divorce is common, remarriage is common as well. So blended families bring several estate planning issues into the mix that have to be discussed and planned for. If you are part of a blended family, you probably came into the marriage with your own separate accounts, with your own property, and your own wishes for what should happen to those things when you die. Your marriage may not mean that you want everything left to your surviving spouse, right? Which the law might assume. Also, if either or both of you have children from a previous relationship, it is only natural for you to ensure that your biological children are taken care of and not accidentally disinherited. Unfortunately, failing to create an estate plan in a blended family situation often leads to just that. In many cases, without an estate plan, when the first spouse dies, a majority of everything goes to that surviving spouse. So then, when the surviving spouse dies, everything goes to that surviving spouse's lineal descendants, their children or heirs, which effectively disinherits the first spouse's children. So you also need to make sure that any planning is in compliance with any outstanding legal obligations. So if you two signed a prenup or a marital agreement, that document probably explains what happens to the money and property brought into the marriage and acquired during the marriage in the event of a divorce. So it's also possible that your marital agreement lays out what happens to those items when the first spouse dies. And in addition, if either of you pay alimony or child support to a former spouse, it's important that you properly plan for what could happen if you die before your obligation has been met. So this possibility may have been addressed during your divorce proceedings, but if not, it has to be addressed to avoid complications at your death. All right. So, providing for beneficiaries with special needs. First, what are special needs? The dictionary defines it as any various difficulties, such as physical, emotional, behavioral, or learning disability or impairment, causes an individual to require additional or specialized services or accommodations, such as education or recreation. So a special needs beneficiary could be your grandchild, child, a parent, a grandparent, anyone else you might know. So in some cases, you can treat these beneficiaries like any other beneficiary. However, you have to exercise extra caution and complete additional planning if one of these special needs beneficiaries is currently receiving or could receive need-based government benefits such as SSI, which is Supplemental Security Income, or Medicaid. So for those individuals, receiving accounts and property directly could result in losing those government benefits, which would be much needed in their case. So in this case, a generous gift or inheritance could be a curse. It could knock them right off their benefits. A trust can allow you to provide for your loved one who is disabled or has special needs without jeopardizing their current receipt of need-based government aid or making it more difficult or impossible for the beneficiary to qualify for those need-based benefits in the future. So we would create a third-party supplemental needs trust in those cases. And now something just to consider if you own a business, some people mistakenly believe that only large businesses need a written succession plan. So even if you're the only employee of your business, the business is an important and valuable item in your estate. It needs a properly documented plan. Um, and before considering the consequences for your business when you die, think about also what would happen if you're unable to participate in it because you're incapacitated. So if you're unconscious or if you're just mentally or physically unable to manage it, right? So if you're unable to work, but still rely on revenue from that business to support you and your family, you need someone who can step in and keep that business going. And what would happen to your business when you die? Do you intend to give it to a child or other family member who's working the business with you? Do you want them to buy out your surviving spouse or other children who don't want to be involved in the business? Can the potential buyer afford to do so? So, is there an employee who can purchase the business, or will your family have to sell to a third party? So it's just best to address these issues early, leaving those decisions to your grieving family can cause tension, fighting, and difficulty getting full value for your business if it must be sold. So planning ahead just ensures that your legacy continues and your loved ones are properly protected. All right. What about Fluffy or Fido? So, as of 2002, Florida law recognizes and allows for making a trust for your pet. So, rather than considering a pet just to be another piece of tangible personal property like a lamp or a sofa, like most pet owners, you probably consider your pet to be your four-legged child. Similar to your minor child, your pet will need a caregiver and money to cover expenses. In addition, pets cannot manage money and need human help. So when we're planning for the care of pets, we consider who is going to take care of them. And as with other important roles in your estate plan, it is a good idea to have that conversation with that individual before naming them in any documents. Some people's lifestyles don't support having pets, although they might love your pets. So have that conversation and then always name a backup, always. And then consider how much money is necessary to care for your pet. Do they have special medical conditions? Maybe they require special food or medication. So cost can be another factor that makes it unlikely for somebody to want to care for your pet, unless you really plan to help that caregiver in your estate plan. And then once we've made that rough estimate, how are we going to ensure that the money goes to the pet's care? So an easy answer is to leave a lump sum to the caretaker at your death if they agree to take ownership of the pet. However, depending on the amount of money left and their ability to manage that money, you may want something more protected and structured. And that's where we would set up a trust for your pet. So money could be placed in the trust for that trustee that gets appointed. And follows the conditions for withdrawals or allowable expenses that you define. And the trustee can be a different person from the caregiver, and that could alleviate the possibility for your caregiver using money for purposes other than caring the pet. So that is a wonderful way to avoid having that pet possibly end up at a shelter or other circumstances. All right, so other important estate planning documents. So now that we've covered several different ways a trust can be part of your estate plan, avoiding probate, protecting your beneficiary's inheritance, protecting a beneficiary's need-based government benefits and pet care, as well as the use of a last will and testament and a separate writing to name a guardian for your minor child, you may think that this is all you need. However, these are only a few of the important components of a comprehensive estate plan. So we're going to get into a little bit more detail of that last will and testament. Um, this is sometimes just called a will, but this is a document that allows you to name the person who will wrap up your affairs after you died. So the will gets filed in probate court. That's where it ends up, and it opens up a probate case for distributing your assets. So this is that document that allows that executor to go ahead and open the probate and handle your affairs after you die. This means your executor is going to take control of your assets, your accounts, your property to manage them and protect them, pay your outstanding bills and taxes, and then give your accounts and property to your heirs. So as we previously discussed, a will becomes absolutely necessary when you are naming a guardian to care for your minor child when you die, because that guardian will be determined by the probate court. It is important to reiterate that first, a will is effective only after your death. So the person you name after you die as executor, they don't have any authority to handle your affairs until you die. And second, if you have accounts or property in your name only, a will does not prevent probate. A will almost ensure that your family will have to go through probate. Okay, so a pour over will, this comes in, especially when we have a trust, and this is the kind of will that we use with a trust. It is kind of a little safety valve. So the idea when you're creating that revocable living trust, obviously, is to avoid probate. But if you have a minor child, we're going to use the will for guardianship. But this is a little safety catch-all, even if you don't have a minor child, because this is a special type of will that is created only if you have a revocable living trust as part of your estate plan. And this will names your trust as the beneficiary. So you're telling the probate court, I leave everything to my trust. And its purpose is just to pour over any account or property that didn't make it into your trust into your trust. So, in other words, its purpose is to pour over into the trust any account or property that had to go through probate because it was still in your name only. So, although your loved ones will have to go through probate if anything was not changed over to your trust during your lifetime, in the end, your accounts and property will end up where you intended, and your ultimate wishes will be carried out, just with that slight detour and a minimum invasion of privacy. Okay, and now on to that financial power of attorney or the durable power of attorney. I'll tell you what durable means because that word is very important when it comes to incapacity. So, first of all, a financial power of attorney is a legal document that allows you to name a trusted person as agent or attorney in fact to handle your financial matters on your behalf. As with most estate planning documents, this document can be customized to meet your specific needs. So, first, you have to decide what transactions or affairs you want your agent to handle. A general financial power of attorney is very broad. Typically means your agent can almost do anything and everything you can do for yourself. There are specific powers under Florida law that have to be specifically enumerated and individually signed or initialed um, by the person that is granting power of attorney, and those come into play. The majority of them is surrounding trusts. So there are certain things that do have to be specifically stated and initialed. But it is very broad. So this means you're almost letting that power of attorney, that agent, do absolutely anything financial that you could do for yourself. The opposite of that would be a limited power of attorney. So if you were to narrow the scope of a power of attorney with a limited financial power of attorney, you would be naming specific transactions you wanted your agent to be in charge of. So those you would typically see when someone is not available, like to sign a real estate deed at a closing. The financial power of attorney grants somebody else the authority just for that one specific thing, to sign that one specific deed for that one stated real estate transaction and nothing more. That's a limited power of attorney. But for comprehensive estate planning, a general financial power of attorney is typically a better choice to ensure that someone is able to step into your shoes when you're alive, unable to manage your property and affairs. So in Florida, a financial power of attorney allows your agent to begin acting on your behalf as soon as you sign the document. And although that might sound scary to grant that power to someone before it's needed, you can, rest assured that you are still able to conduct your own business. So with an immediate financial power of attorney, think of your agent as another pair of hands. Also, that power of attorney is a useful opportunity to see if your chosen agent is up to the task, because you can observe what your agent does and remove that agent at any time, as long as you're mentally able to do so. Last, this is where the durable power comes in. So in Florida, you can make your power of attorney durable. That means that your agent is able to act in the event you become incapacitated. This would prevent potentially the court coming in and taking control of your assets because you were incapacitated and they needed to make you a ward of the state and appoint a guardian for you. So the durable is wonderful because it has the power of attorney stay intact even if you become incapacitated. So this means that that power of attorney would still be effective. And durability is supremely important because in many instances, the reasons clients even have financial powers of attorney prepared is so that someone can act for them if they can't act for themselves. So that's a lot. And that's, what seems like a simple document in that financial power of attorney, it can play a really important role if you do become incapacitated. So if you've signed a general durable power of attorney, you have already named someone to make important financial decisions on your behalf. Without that document, your family would be forced to go to probate court or to have someone appointed to handle matters for you. And that's where that conservatorship or guardianship, those kind of things you hear about, those proceedings, sometimes they're called living probates, would happen, which of course are time consuming, expensive, and a public process that, during a stressful time for your family. So this can be avoided during with some estate planning. Okay. So a durable medical power of attorney in Florida, we call this a healthcare surrogate designation. This is a document that allows you to select a trusted person to make medical decisions for you or communicate your wishes if you can't. This is only dealing with medical situations. So failing to do this could require your family to have a judge appoint someone, which obviously would be time consuming, expensive, and public. But also, you could end up with someone who you never wanted or would have picked to make your medical decisions for you. So think carefully when you're selecting an agent. This can be a really emotional role where quick decisions may need to be made. So some things to consider is, can the person handle this level of responsibility and stress? In the event of emergency, how fast can they get to you? Are they close by or are they on the other side of the country? And always when you are creating that healthcare surrogate designation, and even, you know, your living will for even general powers of attorney, always consider naming a backup or a successor. And then the living will is the next document, and we'll just cover one more after this. So a living will is sometimes called an advanced directive. This gives you an opportunity to communicate with your loved ones, caretakers, and medical providers about your exact wishes regarding end of life care. So this can be a really helpful document if you can't communicate your wishes yourself. So instead of your loved ones trying to figure out what you wanted and probably fighting about it amongst themselves, you have a way of giving them the peace of mind that comes from knowing exactly what you want. So this designates obviously who you want to make medical decisions in that healthcare surrogate. The living will goes a little bit further because it gives specific guidance about the decisions the agent and the decision maker may be faced with making when you're in an end of life situation, such as a persistent vegetative state or terminal condition. So this does supplement your medical power of attorney, and it can be very valuable. So the next document that we will discuss is the HIPAA authorization form. This one is something you've probably filled out at some point at a doctor's appointment. It's called so HIPAA stands for the Health Insurance Portability and Accountability Act. So HIPAA is aimed at protecting your information, but it can be a hindrance to family members and individuals in charge of managing your affairs and making decisions on your behalf. So unless this document is signed, the individuals you appoint may not get access to your medical information or have the ability to speak to your medical providers or your insurance company sometimes. So that access, could be something as simple as getting a test result, or an emergency situation, just a status update on your condition. And just because to note just because you grant somebody access to your medical information with that HIPAA authorization form, they can't make any medical decisions on your behalf. So this is only to receive the information. So that is reserved for your healthcare surrogate under that healthcare surrogate designation. Um, or it could be somebody who is appointed, your guardian in a guardianship proceeding. However, by at least providing information to your loved ones, you can help really ease tensions or offer some clarity in uncertain times. So just letting people know as you designate them as a surrogate, or that you've released a HIPAA authorization for them, that they know that they would be able to gather that information should they need to. All right, so those were the healthcare forms. So what should I do next? All right. So my invitation today is definitely to contact our law firm. Thank you for watching the webinar. I'm sure you have, either taken some notes or perhaps come up with some unique questions based on your personal circumstances that I can definitely help you address. So just because you attended today's webinar, you can schedule a free consultation. And you can also receive an informational brochure about living trusts in the mail when you set up your consultation. And then as we discuss your personal needs and goals, you will be able to take advantage of a special package offer. Just mention that you did watch this presentation. And the way to get in contact with us is either by calling our office at 772-466-0707, or you can email me. You can put in the subject line, webinar, and just provide me with all of your contact information, your phone number, your address, and just let me know you're requesting a consultation. We can do a consultation whether or not you already have an estate plan. So we can start from scratch, or you can certainly bring in your current estate planning documents for a review as well. We are online on the web. Our website is bbblegal.com. If you're scheduling your consultation, you can choose whether you'd like to meet me in Port St. Lucie or Stewart. So I hope you enjoyed this and it was of value, and I look forward to meeting you soon. Have a wonderful, wonderful day.